that it does matter when people get scammed and get ripped off, that it does matter when we talk about our broadband build out in terms of making sure that people have access to technology, access to information so they can compete, whether it's a kid in school or whether it's a small business. And recognizing that people have a right to privacy as well. And people have a right to know. People have a right to notice. They have a right to consent to this information because it's their information. So there's no easy answers here, but I think it's a wonderful conversation that Vermont should have. But let's do it together. Let's do it together and demonstrate that we can strike that balance between economic growth, innovation, and privacy and consumer protection. I think we can. And let's position Vermont in a way that it's great for businesses, recognizing that we're in this global economy, but it's also great for people. It's great for kids. That's what I hope we get out of this. So thank you all for being part of it. It looks like we got a packed house down in White River. We got 3 people.
We have five total, except
Okay.
Seven to talk to somebody upstairs, so she's not here right now.
All right. Well, let me turn it over to my great chief of staff, Charity Clark, and to Ryan Krieger, who from my office, who you all know, who's really a subject matter in this, who we certainly lean on in so many ways to help us navigate these complex questions, and just encourage all of you to not only participate in this process, because we know there's going to be legislation, but to talk to us. We got to hear from you, because if we don't hear the concerns, we're not aware of them. And we all know that we want to make sure that we can, if there is legislation, that we can go in together as a united front saying this is good for Vermont. It's good for people of this state, and it's good for the future of this state. That's my hope. I look forward to working with you, and thanks for being here today.
Thanks, Dave.
Thank you.
Thank you. Good to see you.
Good to see you, Pam.
So I do think it makes sense for us to go around and just reintroduce ourselves. Ryan hopefully has called up the list of participants. So I'll start. Why don't we do this first, and then we'll go to the folks online. I'm Charity Clark, Chief of Staff for the Attorney General's Office.
I'm Ryan Krieger, Assistant Attorney General with Public Protection Division.
Hi, I'm Zach Caminelli. I'm with Vermont Public Interest Research Group, VPIRG.
Hi there, I'm Sebi Wu, also with VPIRG, Vermont Public Interest Research Group.
If I had planned it better, I would have required each of us to name the plow associated with our school district where we live.
My plow is named Carl.
Carl. Oh, that's a good one too.
All right. Focus on this. Jim, how? All right.
We'll move on to the next person. I don't know who's at 215-910. You want to unmute yourself and introduce yourself? All right, we'll come to you. Can we have the next number, 802-279-35?
Hi, it's Tammy from Internet Coalition.
Hey, Tammy.
How are you?
Good. Andy.
Hey everybody, Andy Kingman, state policy for TikTok.
I'm still waiting for you to take me up on my offer to be your cat video reporter for your newsletter.
I'm still waiting. Any
Great. Bridget Morris.
Hi, Charity. Bridget Morris with Morris Government Affairs on behalf of a number of different clients. Thank you.
That's right.
Good afternoon, Charity. Thanks for having us all. Chris Rice here from MMR. Similar to Bridget, have a number of clients interested in the topic.
Damon Devani.
Hello, I work with VMAC, which is a nonprofit that's working through VTC. It's a bit of a hierarchy there. We have many clients, all manufacturers, who would be interested in data privacy updates.
I'm glad you're here. Have you folks participated in the previous forums?
I signed up for all of them. However, I was only able to make this one.
I'm really glad you're here. That's great. Gabrielle.
Hi, did you say Gabrielle?
Yes.
Okay. Yes, it's Gabrielle Molina from Downs, Racklin, Martin. I'm listening primarily on behalf of Apple. Thank you.
Thanks for being here. Jamie Fian.
Hey, good afternoon. Jamie Fian with Primer, Piper, Eggleston, and Kramer on behalf of CDIA and a number of property casualty insurance companies.
Great. Jim Dornado.
Hi, Jim Danino, also with Primer, Piper, Eggleston, and Kramer on Jamie's team.
Great. Kashmir Hill.
Hey, I'm Kashmir Hill. I'm a technology and privacy reporter with the New York Times.
Maureen.
Hi, Maureen Mahoney, policy analyst at Consumer Reports.
Pam Dixon.
Hi, Pam Dixon, founder and executive director, World Privacy Forum.
Anton Van Center.
Hi guys, Anton Van Sevender. I'm here with DLA Piper on behalf of the State Coalition. Great to be with you.
Glad you're here. And Senator Clarkson has returned, so do you want to introduce yourself?
Yes, hi, Allison Clarkson, Vice Chair of Senate Economic Development, Housing and General Affairs.
And TJ, any remarks? He had
I'm sorry, TJ, to have missed you.
Yes.
Well, there we are. We have a pressing, evolving issue that I needed to speak with the town manager about.
Well, I'm glad it coincided with our meeting.
Exactly.
Anyway. There's a couple people called in who I didn't know their names, but if you haven't introduced yourself, if you could do so now, that would be great. Okay, we'll just be stealthy. That's fine too.
Be stealthy. I don't know. This is a meeting about privacy. I'm not sure stealth has a place.
Yeah, that's right. So here we are. We heard from the Attorney General some of his thinking. I know some of us feels like we're having a similar conversation over and over again. I'm getting from Pam that I might not be able to be heard very well. Can folks hear me okay?
It's a little bit in and out. I don't know how to help it with a mask. Masks are difficult. But if there's any way, I think you could get closer to a microphone. I think it would really help.
Where is it?
It's on my laptop.
Do you need
the camera? We can make it closer and we'll do that.
Well, you don't see me anyway. I mean, you don't see us, and you work with us.
All right, now I'm hopefully much louder. Okay, good. Thank you, Pam. So what I was saying is we heard the Attorney General talk about some of the areas that obviously continue to be of interest to him. I would love to do is go through those topics and see if anyone has something they want to weigh in on, respond to. What we're hearing is those are the topics that are likely going to find their way into a report that we will be making to Senator Clarkson's committee, as well as the House Commerce Committee. So now is the time. If you have something to say about it, let's have the conversation. As I emailed this morning, feel free instead, if it's easier for you or just preferred, to send those in writing. After this meeting, Ryan and I will get serious to start thinking about putting pen to paper. So the sooner you get it to us, the better. I would just ask, please get it to us by the middle of December, because by then we will have been making, I think, probably meaningful progress on that piece of paper. So, so here we go. The first thing that the Attorney General mentioned, of course, was Biometric Information Privacy Act, and he mentioned the private right of action. So I just want to, we've talked about BIPA, obviously, in previous forums. Does anyone have anything else that they want to add or new that they want to say about a private right of action?
You mean other than not to have one?
But Jamie, why? Why not? Why shouldn't we have one?
I mean, I think your enforcement powers are significant, let alone your ability to bring suit, your treble damages, your attorney's fees is quite a deterrent for companies that may want to act in violation of whatever Vermont passes.
So what we have is sufficient.
Absolutely.
Is there
Right.
what's the risk of extending that to a private right of action as well, so that the individual consumer has the right and not just, I'm kind of playing devil's advocate here, but just to tease it out a little bit.
Well, I'm mindful of what Attorney General Donovan just said. When we try to all work together and come in with consensus with businesses, I just don't see that as a tool that will sort of reach that goal.
I think I'd also weigh in here a bit on, obviously there's the business concern about a private right of action, but from the consumer perspective, which is also, the other side of this bill and the goal to protect consumers, there's a good deal of evidence looking at private rights of action like this in other states that it primarily benefits the plaintiffs' lawyers who file the suits rather than the consumers who are part of the class action. We're happy to send over the studies that have been done on that. So we just want to emphasize that too, on the consumer side, it's not a great tool.
Any plaintiff's lawyers on the call? Just kidding.
I couldn't hear that.
Could you repeat that? Senator Clarkson couldn't hear.
I mean, are you saying consumers, this won't benefit consumers?
That the primary beneficiary are plaintiff's lawyers, not the consumers themselves, I think is the theory. Maureen, I see your hand is up.
Yeah, I just wanted to highlight how important it is to have strong enforcement to incentivize companies to comply. And, it could be worth considering different models of a private right of action. I know in a Washington state privacy bill, there's an injunctive relief only private right of action. So, I think it's worth, putting different models on the table to consider.
Is there a model in particular, Maureen, that you like?
I mean, our preference would be, a really strong private right of action. But I'd be happy to, send over some different models in state privacy legislation that's been proposed.
I think that we could attach that to the report too. If you submit us something, we're thinking we're just going to attach them so that everyone has the benefit of reading what folks submitted.
And we'd be very interested to see those reports about, the claims that class actions don't benefit consumers. I think I've seen arguments that they do. There's also the question of if part of the goal of this legislation is prevention, is to have the strongest enforcement mechanisms to prevent companies from violating the law, then the question of where the benefit goes is definitely one that we care about, but also the fact of the preventative measure is something that we want to be thinking about as well.
Right. Pam?
Yes, hi, thanks. Of course, this is the question everyone from all sides falls on their sword over. So I'd like to avoid falling on my sword here. That being said, and I know Andy Kingman has heard me say this before, but I'm going to say it again. No matter what Vermont decides to do here, there are groups of vulnerable people, particularly victims of domestic violence and other crimes, that really need protections against harms in this area. It's really important. And I think we've got to consider these vulnerable populations in any legislation. And if there is no PRA, then these folks need to have a way to solve their problems and to get relief very, very quickly. If there is a PRA, I do think there still needs to be a mechanism for vulnerable populations to get relief quickly. Lawsuits take years. So I think it's really about protecting consumers, protecting particularly our vulnerable consumers and children as well. So I just think back to the children who had their images scanned by Clearview AI. and made part of a commercial algorithm. I don't think any of us on this call would agree with that. Collecting data of minors without consent. I think those kinds of super ugly practices can definitely, we should set forth some boundaries, and with the intent of not harming business, but the intent of protecting vulnerable people. Thanks.
Do you have any models to look at in terms of enforcement mechanisms that can be customized to, those kinds of populations that don't fall into the whole litigation delay issue?
Yes, I do actually. They come from the telecom sector where there are carve-outs specifically for vulnerable populations, and I will dig them up and I will send them to you. Thank you.
Yeah. Follow-up question. So are you saying that it might be one model to have, minors, for example, identified as they have a private right of action, but adults do not?
No, I'm actually thinking of something different. I'm thinking that there should be real prohibitions on certain vulnerable populations, and there can be considerations for those populations so that the harm stops immediately. In other words, there's disgorgement of, in the Clearview AI case, there would be disgorgement of the images or facial templates, and in the case of people who are otherwise vulnerable in other ways, disgorgement of misappropriated profits, disgorgement or immediate removal of phone numbers or addresses, et cetera, depending on the use case that we're talking about. But yes, thank you.
Got it. Anyone else want to weigh in on private right of action?
Well, just on the record, I think we said it in previous hearings, but we're all kind of weighing in. I will fall on the sword of we support a strong private right of action. We think that is critical, and for anything that you might change about HIPAA or any of the issues with the Illinois law, we think the private right of action is what separates it from the other laws in terms of strong enforcement for consumers. I appreciate both Maureen and Pam's comments on, that doesn't mean that not open to exploring sort of alternative possibilities there on how to make that happen. And I appreciate the Attorney General's, comments about trying to find, common ground. I think it's worth recognizing, and at the end of the day, this is what policymakers, make decisions about. There are certain things that I think not everybody on this call is going to simply agree on, and this is likely to be one of those, and that's okay. But I wouldn't want this opportunity to go by to say we believe that it actually does benefit consumers, and would actually be happy to look and see. I'm sure Andy has some information about it supporting plaintiffs' fees. I think we could probably find some information about how it is important for consumer protection.
May I ask the group another question? So digging in on that private right of action with regard to BIPA, I think that there's kind of two prongs of why that is found to be so objectionable. So one is just that there is a private right of action, but I remind you that our Consumer Protection Act has a private right of action. It's had one for 50 years, and that hasn't caused Vermont to become, a haven for class actions. I think the issue with BIPA is the $1,000 liquidated damages or $5,000 for intentional violations, and not phrased as up to $5,000, but actually $5,000 for any violation, for an intentional violation. So is it possible that there can be a private right of action structured? Maybe the really objectionable part is those fairly high per violation penalties, coupled with the fact that there's not leeway to adjust them by the court. Could that be possibly a point of compromise? Creating a remedy that is a little bit more flexible, coupled with a private right of action. Could that be something that maybe folks could work with, or might have thoughts on? Guess not.
You're full of ideas, Brian, that no one wants to comment on.
We appreciate it.
I
tried.
I was following along. TJ mentioned a few things I'd love us to touch on, so I'll move on to those other things unless someone wants to weigh in on private right of action. I think that's probably right. You know, we're not always going to agree, but it's helpful for us to have the different perspectives. And if folks would follow up with, you know, the models, the data that you mentioned, that would be really helpful for us. So the second topic TJ mentioned was the CCPA, and I particularly am interested in one piece of that, which I did mention this morning in my email to everybody, which is data minimization. And I'm wondering if folks have thoughts about either how that went in California, other data minimization models out there. This is something that we talk about a lot. Obviously, Ryan is the person who kind of receives the notice, or is supervising the person who receives the notice when there's a data breach in Vermont. And we get notices of data breach, more than one a week. Is that fair, Ryan?
Oh, more than one a day. We
get more than one a day. Data breaches are incredibly common. And of course, a data breach that happens and you don't have any data is not a crisis. And so we think a lot about how can we help businesses be more mindful and do a better job of just not collecting that data. Anyone who has a small child knows that the school, if you're filling out all of this data for the school, of course they have different rules, but it does kind of make you think when I go to the birthday party at the trampoline place in my town, like, do they need all this information to be stored at this small business location? So I would love to hear thoughts if folks have thoughts about data minimization, regulation, policies, what's worked elsewhere, ideas that you have. Damon.
Greetings. My previous employer was actually in Washington State, so we had many customers when California's CCPA was released. When that happened, we had a bit of knowledge of GDPR, and so what kinds of implementation requirements would be there, and it was a lift. However, now that both CDPR and CCPA have been live for quite a while, the technical implementations are all there. All of these either steps to clean your data or tools within large software providers, they're all available. It's no longer a huge burden for companies to cleanse their data or to put together healthy practices of removing it on a schedule. So frequently in the past, you'll hear arguments that it's going to be a lot of work for local businesses to adapt. That still may be the case depending on how they're set up, but the tools are available there for them. The ground has been laid for us. So I think that's an excellent step in the right direction.
Can I ask this might be an ignorant question, but of course in Vermont, we're always aware of our small businesses. We have a lot of small businesses. And while the definition of a small business by the Small Business Administration, I think, is fewer than 500 employees, that's like almost every employer in the state of Vermont has fewer than 500 employees. There's like 30 that have more than that. So I'm curious about what you just described, somewhat of a sunny view. Do you think that small businesses would have access to that kind of ease, or would this actually be quite a lift for a small business to plug into?
So with a large business, I think it actually becomes more complicated to implement just because they have so many sectors, branches, different touch points for their data. It's gonna vary a lot. I can't paint a rosy picture for every business. If you are in the business of selling people's data, obviously you are fervently against these sorts of acts. However, for your average business, like we work in the manufacturing industry, manufacturers shouldn't have a problem, even if they're small size. VMEC works exclusively with small to mid-sized businesses. It's usually just a matter of either working with your local tech company like an MSP, or even one or two IT people, and the tools are accessible. You don't need talented programmers or a development team or anything like that. It's very applicable to more admin style positions that Vermont companies do have access to.
Okay, that's helpful. Pam, did you want to weigh in on this?
Yes, thank you. I just had a couple of thoughts for contemplation. So the first is there's a lot of data governance tools that have come from all over the world. So we now have 145 jurisdictions, 146, depending on how you count, that has either passed GDPR regulations, pure clones, or very close. There's an additional 3 jurisdictions coming online, I think within about a year, including India. But the thing that's really come out of these is there are real challenges. As the economic level of a country is lower, there is increased challenges with meeting the demands of these kinds of regulation. However, data minimization is the one area. There are a couple of areas, but data minimization is one where it does seem like it does allow, there's a facilitation now available for a lot of different kinds of businesses in a lot of different economic situations. And I do think it is feasible. There's a lot of online data governance tools that are readily accessible now. That being said, I would like to contrast that with the requirements in the CPRA that businesses collect a lot of data for opt-out purposes. These two items are really in opposition to each other, and it is difficult, and it does create data silos for businesses to gather and keep all the opt-out data. So I do think there has to be a balance there, and there are real mixed results there in California. I think most people on this call have heard me say we did a study. Unfortunately, we started just before the pandemic, so we haven't finished it yet. We haven't published it yet because of that. But we had started studying how businesses were complying with, the opt-out mechanisms, and most businesses that we contacted just said, oh, we don't have your data because it's encrypted. That's fine. I think we need to incentivize encryption of data stores. I think that's a really good business practice. It should be a goal. But I think it really bears rethinking. What do we want? What are the real goals here? Do we want data minimization, or do we want data collection, or what do we want? Because, you kind of can't have both. You have to make decisions that will facilitate a good outcome for consumers and for all of the stakeholders. And I think that is an area that would really be a fruitful area for discussion with all the stakeholders, because I really feel like that is an unsettled question in California. Now, the European studies of GDPR have come up with some very troubling conclusions about the data collection in Europe. It has caused significant levels of increased data breach and increased problems. So they too are looking into ways of tokenizing the data and doing other things that will ameliorate the problems here. So I think that some of the data is now coming in, and we're now starting to see more nuanced issues now that the regulation has been in effect for a while. And I would also point out that in the past 2 years, most all of GDPR has been derogated because of the pandemic. I mean, huge swaths of it. In other words, they have been lifted. So I think that if we think about business, we also have to think about emergency situations and what we want to happen during emergency situations and how that would look. Now that we've lived through and still are in a pandemic, I think it's really become quite clear to a lot of folks that, the emergency, just lifting all of the data protection rules, or most of them during an emergency, if the emergency lasts for 2 years, that is a really difficult situation. We have it right now with HIPAA. In GDPR, we have it with all the vaccine credentialing systems and a whole lot of other systems. It's just something, these are a lot of things to consider as you think about that very complex question. Thank you.
Can I throw out a question here? It seems, and just to, we've talked about data minimization, and maybe everyone's on the same page of what data minimization means and what we mean by it, but I think, it's probably a lot of interpretation as to what that could mean. I'm looking at the section from CPRA, and I'm just gonna paste it into the chat, and I'm just throwing this out there by means of an exemplar, not anything beyond that. But it seems to me that, and I suspect that for a lot of people, this is the first time they're seeing them, and for other people on this call, they've probably already read this and kind of absorbed its meaning. But it seems to me that when we're talking about data minimization, what we're really saying is that a business is only going to collect the data that it needs to accomplish what you think you're giving them the data for. And then they'll only hold on to it for as long as they need to accomplish that, and they're not going to do more with it than they said they collected it for. It seems to me, and correct me if I'm wrong, if you had really good data minimization, then when consumers want to have their data deleted, it's usually from a business that they didn't consent to have their data in the first place, or that collected far more data than they expected, or perhaps they gave them the data and now they no longer want to do business with them, and so they want to delete, their information. It seems that if you have strong data minimization, maybe that addresses a lot of the concerns consumers have that would cause them to want to have their data deleted, right? If businesses had to proactively delete the data themselves when they no longer needed it, or weren't allowed to collect it in the first place if they didn't need it, and if a consumer is only giving data to a business to accomplish what they have contracted with that business to do, provide a service, provide email, whatever, then maybe the opt-out and the deletion becomes less of a concern as long as we get the data minimization right. Is that overly sunny view of things? I see Maureen has her hand up.
Pam's nodding. Maureen, do you want to respond to that?
Sure. I hope I don't have a different view than Pam, but so first of all, for CPRA, it does have data minimization language that will kick in when that goes into effect in 2023. But just speaking on behalf of Consumer Reports, we'd like to see tighter data minimization language. I think CPRA, not being able to see the chat right now, I think CPRA says something like you're only allowed to, process what's necessary for the listed purposes. And I still feel like that leaves companies too much leeway to list, any potential purpose and then, get around the data minimization rule that way. So we prefer language that limits processing to what's necessary to deliver the service that's requested by the consumer or expected by the consumer. That sounds reasonable too. And then I agree that you wouldn't need an opt-out in that situation, because if they're only processing the data that's necessary, then what's there to opt out of? So I don't think that opt-out would be necessary. For deletion, I still think that could be useful if a consumer, wants to delete that data earlier. That's my knee-jerk reaction, but I'd be interested in Pam's thoughts.
Pam?
Yeah, just a couple of thoughts. So I think that one of the problems that the CPRA was trying to get across and get to is the problems that we all have with secondary uses of data that was originally collected for one purpose and then utilized for another, and maybe many others after that. This really, if you think of privacy as a really complex network, this is really a big link of the chain. So I think that whatever we can do to reduce the secondary use of data, that's important. And Maureen's right. The various clauses in the CPRA are going to allow for quite a few bits of wiggle room there. I think it's really important to for businesses to state, in a privacy impact assessment or some other risk assessment tool, what do they need the information for? What are the specific uses they agree that they want to use it for? And then, stick to that. One of the really troubling things during the pandemic has been the amount of data that is coming from the private sector, which is being touted as utilization for public health purposes. So all of a sudden, we have all sorts of entities that are now quasi-public health authorities. I think that, I enjoy logging on to Apple and looking at the aggregate, state level and country level statistics about movement. I really do. And I think they've done that responsibly. But I do think that is a use of data that I certainly wasn't expecting. Now, is it useful? Yes. What do we think about that, though? Can we please, think about all of these secondary uses a little bit more? It's very difficult to argue with truly, genuinely aggregate uses of data. But anything beyond that, where it's potentially re-identifiable, I think is very problematic. So this brings in some additional ideas. So for example, what is the definition of secondary use? Can you aggregate data and then utilize it, for example, for public health research purposes. We don't want to shut down data sources, but at the same time, they have to be safe, and they have to be especially safe for consumers, because otherwise we create a really ugly cottage industry that's really pernicious. So how that can be accomplished, I think, is by having very robust and clear, crisp definitions of aggregation, prohibition on re-identification with consequences, and those sorts of measures. And I think in this way, and also by really, as Maureen said, narrowing down the circumstances in which you can state what you're going to do. We shouldn't have a Pandora's box within a couple of clauses in a privacy policy, So I think that closing that loop a bit more would be very helpful with more crisp definitions. I hope that's helpful.
That's extremely helpful. So now I'm hearing, okay, data minimization plus clear guidelines on secondary use. If those are in effect, then maybe the opt-out and the deletion becomes less of a concern, because I agree with everyone that the opt-out, it creates a lot of added complexity to the system. Though, so now it occurs to me that when we talk about secondary use and when we talk about data minimization, that is entirely a burden and an obligation on first-party data collectors. There's an assumption that there's some sort of handshake going on between the person providing the data and the person collecting the data, and that person then has to use it in a certain context. So now let's bring in the third-party data collectors. What does data minimization mean with regard to a business that has collected this data or somehow come into contact with this data and has made no promises to anybody about what they're going to do with the data? And so there's no context in which they collected it or purpose. They collected the data for the purpose of collecting the data and probably reselling it, right? So how does this work? How do you bring those folks into the ecosystem? Now, yes, if you really lock down the secondary uses and the data minimization, you're cutting off a source of a lot of data to third parties, which is great, but there's still going to be a lot of data being collected outside that. And so how does that work into a schema? Is it possible that the deletion only works for the third parties? For third parties, there's deletion, and then for everybody else, there's minimization and restriction or guidelines on secondary usage? How, without having to bring in a right to delete or an obligation to delete, how can we expand this to incorporate those third-party data holders? Any thoughts?
Hi, Phil. Unless Pam, is your hand still up from before? Okay, Phil, hi.
You're on mute.
We can't hear you. You're on mute, I think.
Thank you. And sorry to join late. I was having Wi-Fi problems. I'm out here in California, actually quite far away. But yeah, I think you raise a good point here. And we represent third-party collectors, right? So the data they get is, and by the way, 90 plus, if not more, of the data they get is from publicly available sources. So one thought, and I don't know if this has been raised in your earlier calls, is that every state now that has enacted a comprehensive data privacy law has excluded publicly available data from regulation because for constitutional reasons, you can't really regulate that data. But separate from that, I think the solution is opt-out for the issue you raised. It's not deletion. I'll tell you why. Deletion, if you look in California, is limited only to data that is provided directly by a consumer to a company, as opposed to data about a consumer collected from a third-party source. And there's a reason for that. One is to get to, I think, what Pam source. If you cut off the data at the source where it's given in the first instance by the consumer says delete it, that really prevents that initial source from passing it on making it publicly available and allowing companies like we represent to collect it and use it. So it makes sense there. It also does not make sense in the case of these third-party collectors, because we get data, just so you understand, on an ongoing basis from all kind of different sources. And we get new data dumps like once a month, let's say. So if a consumer says, hey, delete my data today, it creates this Hobson's choice for third-party collectors. One of two things. Either we say, okay, great, we delete your data today, we've complied. But guess what? Next month, data about you comes back into our system. We didn't do anything wrong. And we have no way, by the way, of deleting it again because we haven't held back identifying data for you. And you think you've accomplished something, but you really haven't. Or alternatively, we hold back some identifying data so we can delete the next batch, but now we haven't complied in the first place. And I think this is one of the reasons why California limits deletion only to direct collections, number one, and why the solution is opt-out to the consumer. Because what the consumer, I think, wants is for his or her data not to be shared with others. I don't know that they really care that the data is in some server somewhere, you know, sitting around doing nothing. They get concerned when their data is sold for some purpose, whether it's advertising or God knows what, or transferred or given away or whatever. And that's what opt-out does. So I didn't mean to go on at this length, but hopefully it's helpful to you. Because there was some earlier discussion about, is opt-out even necessary if there is data minimization? I sort of agree as a matter of logic. You know, yeah, I guess if the consumer is told right at the outset with the first party collector, hey, you're giving us your data, but we're only going to use it for these purposes. If that really works down the chain and the company abides by it, yeah, the consumer has agreed and there's no real need for opt-out. But I would say that just in the real world today, opt-out exists. Companies have been offering it as a voluntary matter well before the enactment of the CCPA and the like, right? It's something consumers are used to, and it's something that third-party collectors are willing to abide by and offer as a consumer benefit. So my thought is you ought to, there's no downside in allowing opt-out. Let's put it like that. And again, I think that is the solution for a consumer who just doesn't want his or her data disseminated further. It's more than you wanted to hear, but thought I'd add those thoughts.
Thank you. That's incredibly helpful. Phil, what organization are you from? I don't think you mentioned that.
Well, I'm a lawyer in Los Angeles with the Mayer Brown Law Firm, but we represent a number of different companies, but including a coalition of companies that are in what's called the People Search service. So they collect data strictly from third-party sources. And you know, you can go up on the web and search for a new neighbor, a teacher, all this kind of thing. We also, I don't represent them, but we work closely with companies like LexisNexis and Relics or whatever. I mean, there is a whole industry, a whole data industry that you know quite well. And by the way, we are all registered on your data register, on your data broker registry.
Yes, you are.
And one last thing I'll tell you is we were very active in the California debate, and one of the things that we promoted was the creation of a data broker registry in California, patterned after yours.
Yeah, sorry, go on.
And for the purpose of giving consumers this opt-out opportunity, right? Because the beauty of the data broker registry is that it lets consumers know which of these companies exist and who has their data, and you know, and who collects their data and sells it, albeit not directly from them. And if they want to opt out, they can do it. That to me was the beauty of the data broker registry in Vermont, and California thought it was a smart move, and you know, and California went ahead and enacted it. A similar data broker registry. We supported it. All our companies are registered on it. It's very pro-consumer.
So you know, this is some great points you raised. I would note, you know, one thing you mentioned about that consumers don't really care about their data being on a server. You know, as long as it's, you know, it's the selling that they're more concerned about. I would say that one of our big experiences with the Equifax breach, one of the most complained about breaches we ever had, consumers always knew that Equifax was selling their data. They were okay with that. It was when they lost their data that consumers got very, very angry. And that was really about the data being on the server, not the sale of the data. The remedy they would have wanted there was deletion, I think, not sharing. But that's not my point. You raised a really interesting issue that frankly had not been really on the table until now, but public data. Okay, this notion of public data. You're right. There are these exemptions for public data in all of these laws. And what I find very interesting is public data doesn't really seem to be defined very well. Because on the one hand, public data could mean data that's in a government document, right? I think that's probably what people initially meant when they said public data. But for example,
The IRS has a ton of information I do not want to share.
Well, and that raises a very interesting point, because there is public data that governments have been collecting for 100 years, which is technically available through public records requests, but I don't think anybody ever intended for it to be shared. It was public data, but it was obscure data. It had practical obscurity attached to it, and now that's not the case anymore. So you have these different categories. You have governmental public data, a piece of data that's put in a court filing that only 3 people are ever going to read is now available to everyone in the world because it's technically public data. So the answer there is you can either clearly and narrowly define public data, or you can actually change the laws at the state level to define what should be made available to the public. But that's one category of data. The next category of data, and I've seen this, we see it in the Clearview AI litigation, is this argument that basically anything anyone puts on the internet is public data. Everything you do, which is basically how people live these days, right? One of the arguments we're seeing is, well, we got to collect those 10 billion photographs because people put them on Facebook. Right. Therefore, they're public, and there are public exemptions. And since public isn't defined, it's an interesting question. So by this argument, if I just put bugs and surveillance cameras on every corner and just collect everything going on, well, they're outside, they're in the public. I get to do whatever I want if it's public. Yeah, well, it's true. And
private citizens.
Well, so there's that. So there's data that's put out in the internet. There's data that's put out in public, and this also. Then the third issue that comes up is this notion that, okay, yeah, maybe you had data that was in this database and that database and that database there, but when you combine them all together into one database, it becomes something new. It becomes something more dangerous.
Terrifying.
Sure, because it's one thing for someone to know your address, and it's one thing for someone to know your age, and maybe someone knows a health piece of information about you. But yeah, you put it all together and you've got this, 60,000 pieces of data about an individual. Well, that's more like a kind of a authoritarian, dossier sort of thing. That's used for manipulation. That's used for blackmail. That's used for crazy stuff. So I'm really glad that you put public data on the table here for us to talk about. And I'm really curious as to if there's anybody in the audience who would like to talk about the possibility of coming up with a better definition of public data, or not having an exemption for public data, or a very narrow definition of public data, and what that might look like. Do we have any thoughts?
Can I suggest some thoughts on that? Just
absolutely.
Could I respond to the first question?
You
Yeah, Pam had her hand up for a while. Can we hear from Pam?
Is Phil from?
I'll be really brief. So I wanted to respond to the initial third-party question in regards to secondary, tertiary uses, et cetera. So I have a couple of thoughts. So in the health sector, the way this is handled is through business associate agreements and the HIPAA model. I would encourage you to look at that model. I think it really works. So the protections that were applied to first parties flow to second parties and third parties, and through the life cycle of that data entirely through the BA agreements. The second thing is it's really important to understand how data is being utilized in an AI world and machine learning world. So a lot of companies who are having to comply with GDPR, what they're doing is spending a lot of time data tagging so that any data of consumers, of people, that is being utilized for analysis in any AI system is tagged well before it's ever input for analysis. And you can see this in the data tagging available in data lakes and data warehouses today. And I think it's really, really important to understand this particular issue. It flows to biometrics and very significant other areas, from public health to education to hiring, et cetera. In terms of opt-out and the Hobson's choice, I think that we have to really look at data protections and the entire flow of data. So, and this gets to the public data question. So first, let's start with the consumer perspective. I understand the conversation about opt-out, but the balance for that is we can't have people opting out of 1,000 businesses. It's really challenging. I work directly with the National Network to End Domestic Violence, and I train people who work in the shelters. And we sit down with each other and I train them on how to opt people out. And this is why I know that it literally takes a week for people to opt out of all of the people search services and other sites they need to opt out of. And if they miss even one, it can really be a problem. So I would like to see something that makes it easier for everyone to have a unified opt-out so that they can effectuate any opt-out rights in a reasonable way. But as our digital acceleration continues and our data flows continue to accelerate, we have to be mindful that consumers really have very limited ability to find out about this stuff and then to effectuate their rights. And I think that's really important. And I think I'm going to stop there, but I like the idea of having a better, clearer, crisper definition of public data. That's it. Thank you.
So I want to return to the public data question, but I want to follow up with you, Pam. When you talk about kind of the universal opt-out, the Colorado comprehensive law had a universal opt-out, and I've been looking at that language. What do you or anyone else think about that? And so basically, the way I would interpret their law is basically people should have a right to give a technological signal that they should not be tracked or their data should not be collected or sold. It might come out of their web browser or something like that. As far as what the actual technology is, we'll figure that out later. The AG will come up with something and it'll happen in like 2024. That's how I kind of view what Colorado did. And what do you think about that approach?
Yeah, I think Maureen will have a lot to say about this. She's really studied that law, but there's a couple of things I would say about it in regards to a technical perspective and consumer perspective. So the first thing I would say is that we need to get away from the idea as much as is possible from online, offline. That world is gone. We really need to be thinking digital, analog. We're really moving into a highly digitized space where everything is more digital and freely flowing across various methodologies from Wi-Fi to edge and fog computing. It's really we're moving into an era where our activities are going to be very seamless and we're not going to notice the difference. And web browsers really are already showing their age. So I think that having a web browser signal is extraordinarily limited in the world we're going into. We have a testing facility here, which is now very cramped because everything's a work from home. But in our former office, we had hundreds of devices, and all the Internet of Things devices don't utilize a web browser per se. So I think we have to be very careful with that, and that's the main thing I would say. We have to be careful of looking at that.
So then you mentioned universal opt-out. Has anyone done a universal opt-out? And
there's no true universal opt-out that exists at this time. I think we're going to have to look at what I would call a mesh network of protections. We'll need to look at this time with where technology is. Yes, I think it's a great idea to look at web browsers, but we need to also think about personal devices and Internet of Things devices and cars and things like this, and try to figure out an approach for this. And I think industry has a very important part to play here to discuss what might work. I don't have the answers to those questions. I can tell you what the problems are, but for those responses and answers, we really do have to hear from industry on this.
Thanks. Yeah, I would agree with that, although we come from a slightly different perspective. So our strong preference would be default privacy protections through data minimization so that consumers don't have to take any action because, as Pam says, opt-outs just don't work. Consumers don't have the time to opt out of every company that has their data. They don't even know every company that has their data. But our position is, the CCPA went into effect, so we advocated that, the AG adopt rules that require companies to honor browser privacy signals as a global opt-out. Agree that they're not perfect, but we think that it can help make the CCPA a little bit more scalable, and we're working to make it better. And we were part of the effort along with other advocates and academics to help create this global privacy control, which sends a do not sell signal to companies with which consumers who've enabled it, their browsers interact. Another thing that the CCPA has that it had from the beginning is an authorized agent provision, which allows consumers to delegate to third parties the ability to submit opt-out, access, and deletion requests on their behalf. And Consumer Reports is working to develop an authorized agent service to help provide this for consumers. Again, not ideal, and our strong preference would be default protections, but we think that it's something on the margins that could make it easier and more scalable for consumers to exercise their preferences. So, if there is an opt-out law, then we think there do need to be ways to make it more workable.
Let me do a follow-up. So, one of the most successful FTC protections is the do not call list. It's one of the most successful, one of the most popular. Very straightforward, right? You put your phone number on the list, and a certain subset of people are not allowed to call you. And I've been, wondering about what a do not track list or do not sell my data list would look like, some centralized registry, and what would have to go into that list. Maybe it would be, I'm just spitballing, maybe it would have to be like name, address, age, and phone number, say. And this would be a list that would only be available for the sole purpose of certain companies would have to look up and not sell anyone, on that list, and it would be in a centralized. Okay. Has anyone tried or proposed doing something like that? Is that a thing? And what has been the experience there?
I know Pam goes way back on this issue. I will say that Senator Wyden has a bill called the Mind Your Own Business Act, which has such a framework for authenticated data, and then I think like a do not track provision for unauthenticated data. So that's one example of a model that's out there.
Okay, good to know.
Yeah. So 20 years ago, I proposed with what was then every privacy organization in the U.S. a do not track policy. I proposed it to the FTC. The FTC liked it. They held a workshop. But my original thought was that it would be do not track for data brokers, but it turned into a do not track web signal, and it got mired in a W3C process. And it didn't really go anywhere, but the idea has resurfaced different iterations. I think there are a lot of different ways to accomplish it. The data ecosystem has changed profoundly in that time, and I think that I think it's doable, but I think it's going to require a lot of dialogue to figure out what is technologically feasible on all ends.
I want to get back to Phil because we kind of went on a detour, which was really interesting, and Phil might actually have some comments about that. But we can still hear you, Phil, I think. Can you?
Oh, good. Yeah, I wanted to get back to the publicly available data issue, but again, I will just say this. Back on the opt-out signals and the like, I think the CPRA itself requires companies to either accept the sort of automated opt-out signal or the other, and the regulations now are sort of requiring it. But I think I'm not a tech person, which I'm sure is obvious, but I think these tech solutions are going to have to get refined so they really work. But again, speaking on behalf of at least our clients, they'll do whatever. They're glad to opt out the people that want to be opted out. So they're not, looking to escape that in any fashion. I just want to address the publicly available data issue. It's been a big, big issue. It started in California, as you suggested, in the CCPA. It was limited only to data available through government records, right? Data available through government records. And it also was limited to the use of that data in a fashion that is consistent with the purpose for which the data was collected. A number of interested parties sent letters and legal analyses to the California sponsors, including Alistair McTaggart, saying this is illegal. U.S. Supreme Court rulings, more than one, have made it clear that you cannot regulate the use of data that is in the public domain. So, if there's a newspaper article written about any of us on this call, it tells about who we are and our lives, it's publicly available data, whether it should have been there in the first place or not, it is, and you can no longer restrict its use and the like. So when the CPRA was written, and I can tell you I was in the middle of these discussions, the sponsors of that, including Mr. McTaggart, including Senator Bob Hertzberg, who sort of led it at the Senate, they were very concerned that the CCPA was just going to go down in its entirety. From a legal point of view, it was going to be invalidated in its entirety unless the publicly available data exemption was expanded properly to meet the contours of what the Supreme Court has laid out as, publicly available data. So that's what led to the exclusion in the CPRA. And since then, every statute that's been enacted, and there have only been a few, but they have pretty wide exemptions. I think if you're looking for one that lays it out the best, you could look at the Uniform Law Commission model law. You're familiar with, I assume, right? The Uniform Law Commission, interestingly, and by the way, I used to be a member of the Uniform Law Commission a long time ago, but it never took on these kind of issues. It used to take on, it took on the probate law, it took on the most boring things you could imagine, but it decided to get into data privacy, I think, because it thought none of the other national associations were getting into it. And they came up with an exclusion on publicly available information. Here, I can just show it to you. It's right here. I just pulled it out. But it starts with the government records data. Then it goes into data that's available through widely distributed media, right? Including websites and TV and the like. And that also includes like public Facebook pages, right? As opposed to a private Facebook page. And the like, and I would just commend you to look at that. Uniform Law Commission, it's not perfect, but it's comprised of a number of retired judges, lawyers. I mean, these are scholars of the law. I will exclude myself from that group, but again, I was a member of it for a long time. And I think you will see in every state that seriously looks at this, at a comprehensive privacy law, they are careful to have an exemption of publicly available data that conforms to these Supreme Court rulings, because if that doesn't occur, the law is vulnerable to legal challenge. And because the question of what data it covers is central to the law, it means the entire law is vulnerable and it will likely be invalidated if there is a legal challenge. So I can get into the details of why it's, of what the exemption ought to include, but this is the history of it. And everybody's looking at it as going in this direction.
That's really helpful. And I see, Damon, your hand is up if you'd like to go next.
Sure. I think the definition of publicly available data is going to be a point of heavy contention, both now and in years to come. You bring up things like, a public Facebook page, and that could be, expanded to things like, your footprint when browsing websites. If it's available to, the website viewer, how public is that? Or, if you're using a Twitter account, any sort of social media. And those things, while public and brought up earlier, mundane alone, when brought together in unison, are extremely harmful. And that's really the issue wherein public data falls apart, is that little bits and pieces here and there, 50 years ago meant nothing, but if they can easily be brought together, it's theoretically public data if you were to throw a court book at it. However, when we're looking at it in real technology terms today, you can create an extremely specific profile of a person without their consent. And so I think that's where the contention will arise. And as with others here, I don't have a solution to that problem, but hiding behind the term is definitely something that's going to be happening, and it's something that we'll have to grapple with.
Yeah. What about trying to, like, as a compromise, data collected off of the internet is fair game so long as it was collected in compliance with the terms and conditions of the website from which it was being collected, including terms that say, for example, no screen scraping. Would that be something that everybody could agree to? I mean, that seems like a reasonable compromise.
If I may, the people like us that stay up late into the night thinking about data privacy, that works for, and the same could be said for opt-out. However, obviously, the idea of a terms of use or a service agreement on a website, those are legally questionable because they're never read. And I think we'd run into the same issue wherein if you're legally mandated to have an extremely readable and user-friendly version that people can accept or decline, we might be onto something. But as long as it's a 40-page manual that you're supposed to scroll through before you get your weather, I don't see how that holds up to the actual citizen, the people whom this law are supposed to protect.
So in this case, though, the terms and conditions we're talking about aren't so much the terms vis-a-vis the consumer as terms vis-a-vis, other visitors who might be screen scrapers, right? They have like those separate terms and conditions as what you're allowed to do or not do when you're collecting data off the website, right? So that's all I'm thinking about, Like one of the interesting things in the Facebook situation is, yes, someone might set their profile to public and allow things to be made public, ignoring the fact that often Facebook defaults people to public. They don't even realize it's being public and they accidentally make it public. But they do that with the knowledge that they can then change it to private if they so choose. But once that information has been scraped, you've taken away a key protection, which was part of the terms by which the person put the information out there in the first place. And I don't think any consumers are thinking in those terms when they're doing it. They're saying, oh, well, I made this public, I can make it private, not realizing that there are other folks who are, taking away their options, right?
And the damage is already done.
Well, exactly. Yeah. So definitely worth a longer conversation and more consideration.
Phil, I see your hand is still up, and I just want to make sure it's not newly up. If you had something to add. Okay.
Sorry, no, I'm done. I'm just not good with all this hand stuff.
Well,
you're still frozen.
None of us are.
None of us, yeah, exactly. So I have one more topic that I want to raise here, but I don't want to leave. This has been really interesting conversation. I don't want to leave it. If there's something else that someone would like to say, anyone in the room?
Yeah, I'll just one more point on the broader topic of data minimization, which is kind of where we started, and then Ryan helpfully took us down a few different paths or potential pitfalls, which he's very good at always doing. Those pitfalls are very real. I think we should continue to have sort of a discussion on publicly available data, third parties, et cetera. But I think you alluded to this, coming back to and just giving a kind of hearty endorsement of continuing to look at and pursue data minimization. That is an excellent starting point in that it limits so much of the other potential issues here, right? So we talked about this at the last hearing, but the idea of fostering trust between the user and the person taking it. People, at least this is our kind of perspective, consumers don't necessarily mind sharing data with an entity if it's being used for the service that they expect and provide. It's all of these sort of secondary things and making sure that it's securely held and that sort of thing. And the other thing that and Damon was just alluding to this, the other major point that I kind of hope that works its way into the report or discussing it is taking as much as possible the onus off of consumers and individuals to exercise their privacy rights, right? To have that be the default. So we talked about this with the universal opt-out and that kind of thing, but with data minimization, not the idea that we're incentivizing companies and entities to coerce or basically get people to sign away or give away their rights, just to use the product, reading, a whole novel, checking things off. There is this idea of sort of consent fatigue, but just simply having the baseline be yeah, all right, when I tell Google Maps that I'm going to go, to Hartford today, they're using that information to help me get to Hartford. That is the agreement that I entered in. They're not using that information for what else, getting to law enforcement, advertising. It's a bunch of things that I agree with. It's this tacit agreement that I told you that I'm going to go to Hartford and you help me get there. That's the whole thing. So I would just, if we're kind of moving off that, I would just add a sort of hearty endorsement for that concept and take a look at that.
I want to add that data minimization has another benefit, which Charity alluded to. There are huge privacy benefits to it, but also from the data breach perspective. So the AGs have been enforcing in the data breach area for about 12 years now. We've been really pushing this, have good data security, have good data security, have good data security. We're still, the number of data breaches are increasing, they're not decreasing. And we know that a company can have really good data security and still experience a breach because these bad guys are really, really smart. So a company does not have it in their power to stop themselves from ever having a data breach, right? If the Russian intelligence wants to get into your systems or North Korea, they're going to get into your systems. What companies do have control over is what data they collect in the first place. And one thing that we have seen again and again and again is, because we investigate these data breaches, is you see a data breach where half the data that was lost was 10 years old. And it was from clients who aren't even their customers anymore because they just never bothered to delete it. And you think, wow, like this data breach could have been so much more minimized if this company had not had that data in the first place, which they had absolutely no need for. And right now, that's not illegal. It's not illegal to hold that data for a lot longer, but it's just making everybody a lot more vulnerable. And so there is the privacy benefit, but I think there's also a huge ID theft and security benefit of having these very clear standards of data minimization. It seems like it would be common sense to get rid of this stuff, but we do know it's a burden, and we do know that it takes some extra heavy lifting, so maybe there needs to be some incentives, and it would help in that area as well. You got the next topic.
Anyone else want to weigh in on this? So the last topic that that TJ mentioned, he used the word teeth in reference to the data broker registry statute, which has now been in. When did that pass? 3 years ago?
3 years ago, yeah.
So, yeah, I think. So I would just, we in the first forum, we did talk a little bit about making some changes to that statute. We've had 3 years and reflecting on little things that are just no-brainers that we could do better. And then TJ mentioned teeth. And so I'm interested in any and all comments about whether that statute should be peeked into and seen if improvements can be made. Would anyone like to start us off? I'm sure Senator Clarkson is interested in this
very much
topic.
Could teeth mean a private right of action and $5,000 liquidated damages?
I think he's provoking you.
I'm just teasing.
Pam, I see your hand is up.
Yes, thank you. First, I think something very important to do here is to support what has already been done and to ensure that those protections stay. And something that was very, very important for us, actually, as we were researching the Family Educational Rights and Privacy Act across 5,600 schools in the US, was the provision around children and the notices that came in regarding the knowing collection of the information of minors was absolutely genius and very, very important. I would encourage you to keep that. I think it's a very important provision. California doesn't have it, and it's made a very substantive difference in the quality of California's registry in comparison to Vermont. I really appreciated that provision, and again, just couldn't support it more. I think that if you want to take a next incremental step, the next logical thing to do would be to provide opt-out for consumers for every entity that is registered. And I think that the opt-out, in this case, you have a single registry. There's no reason whatsoever that the opt-out could not be global in reference to the registry. In other words, a consumer could just give a signal somehow to the registry, and then all of the businesses would have that signal and then effectuate an opt-out. There is going to come the issue of how long an opt-out would last. I really like the idea of an opt-out that is an opt-out, period, end of discussion. There's also an issue of timing of the opt-out. Is it in 6 months? Is it now? You know, is there an expiration date? All of these questions will come to bear, but I think that opt-outs will vary depending on the business and the type of entity that is being opted out from. There are some very complex data ecosystems in the data broker world as defined by Vermont. Nevertheless, I do think that that's something that needs to be attended to. Opt-out should mean opt-out, and we should really look at defining the idea of data suppression, because a lot of times when we say opt-out, data brokers read data suppression for the reason that, oh dear, who was that? The gentleman who raised his hand from Los Angeles mentioned the Hobson's choice. There are some very serious issues with the data dumps. Some businesses get them daily, and you know, in our heads, we think of data brokers and we think of, you know, paper lists and, you know, even electronic lists. It's really not that way anymore. It's really APIs, data lakes, and data warehouses, and the data moves very differently. So, yes, that's what I think. Thank you.
Follow-up. When you say opt-out, what do you mean by opt-out? When someone sends whatever this mystical signal is to the registry, what are they opting out of, or what do they want to opt out of?
Well, okay, so for kids, so I'm just going to start with kids first. So I believe children should be opted out of all uses of their data, including for AI analysis and analytics. This would have stopped the Clearview AI problem. And it would also stop very large data brokers from utilizing the data of children to make inferences, for example, about their parents or about anything else. And I think this is a very important protection that we can give to children. There really should be no argument with this whatsoever. If it's data of a minor, it shouldn't be used, including for AI analytics. And children, parents should be able to opt their kids out of that kind of use. The second thing I mean by opt-out, and that should be permanent, by the way, this is really, it needs to be permanent. The next thing I mean by opt-out is that a consumer would come to the Vermont registry, and the idea is they would give their information and the mystical signal would happen. And then the data brokers would no longer, in the case of people search sites, would no longer display their information or have that information available to display. There are various ways of suppression. There would need to be some discussion with the industry as to how they can effectuate that, but it's very important that there would be no slips. And I think that there should be some carve-outs for people who are victims of crimes and other vulnerable people who have very significant safety considerations. For them, I think they need the right to delete. I think there are different considerations there, and we've seen too many issues, too many deaths, and we've got to stop that. And I think we have it in our power to do so. And the other thing I think opt-out means is that the information is not available to additional uses. Now, how all of this happens, I think, is actually fairly complex. You know, we can all put words on a page, but to actually accomplish these things is actually quite difficult. But nevertheless, this is really important, and I think it's worth the effort to get it done. If we can figure it out now, it will make it a lot easier for us in the future as things get ever more complicated, and hopefully we can start to develop some best practices in this type of complex opt-out. Thanks.
Okay, another follow-up for you or anyone else. When we talk about opt-out, how does this work with background check companies who are part of this ecosystem and are, you know, data brokers as defined in our law?
Yeah, background check companies are regulated under the Fair Credit Reporting Act. If they're not, they should be, and they have to follow that federal law. And I think that's just very simply put. You cannot opt out of a background check if it's a regulated background check. Now, if it's a fake background check that someone's doing inappropriately, that's a different situation.
So would you say that entities and data within entities that Fair Credit Reporting Act covered would not be subject to the opt-out. It would only be non-Fair Credit Reporting Act data. Is that the suggestion?
Yes, that is true. The Fair Credit Reporting Act data is regulated, and background check activities are regulated. Now, if a company is taking regulated FCRA regulated data or GLBA regulated data and utilizing it for other purposes, that's a whole different level of non-compliance, and I think that's something that's a different conversation. That is not complying with a federal law. Maybe two federal laws, yeah. But it's not entity level regulation. It's really activity level regulation. For example, there's a lot of background check companies, or at least some background check companies, that will have a regulated arm and an unregulated arm. We've seen this before, where the unregulated arm will do social media searches, for example, and so on. Now, this is not as gray of an area as it was 10 years ago. But nevertheless, I do think that a formal FCRA background check really should not be subject to the data broker opt-out, because you can't opt out from that. That's a federal provision. It's tightly regulated. But any, if that same entity, if they're doing these other kind of quasi background checks that are unregulated, and there's lots and lots of data to look at for an unregulated background check, I think they should be subject.
I mean, it's an interesting idea because, there are marginal cases. We do see businesses that say, we're not Fair Credit Reporting Act regulated, and we think, yeah, we really think you are, and there's a big argument. But if there's this opt-out, it would be, well, if you're not, then you have to delete the data, or you can't, you have part, so it's universal. And if you are, then you're regulated under feds, but you have to choose one or the other. There's no way to slip between the regulatory regimes. So that could be an interesting
I think that's exactly right.
Any other thoughts on this topic?
Well, on the topic of data brokers
Yes.
and teeth. Well, so when we talk about teeth, that can mean a few different things. And a lot of what Pam was just describing, I think, describes sort of additional protections for consumers, and totally on board with that, yes. But and then teeth, in terms of the existing law, I guess this is maybe a question, and maybe you don't want to answer, or you're not, but like, for people who are violating the existing law, is what we have sufficient? I mean, what we just heard, and I think one of the arguments that we were making when we were pushing for this law, and I think it turned out to be true, is that to some extent this registry provides a bit of a safe harbor for good actors to come forward and say, yep, hey, we're data brokers, and this is our practices, and this is what we do, et cetera. And it sounds like that's played out in a number of ways to the point where that was suggested by, it sounds like, some of the data broker industry to be included in California. So the question would be, there obviously must be brokers who aren't registering right now, and we also know that there are brokers who maybe are registering but are providing incomplete or inaccurate information as part of that registry, I don't know if I'm equipped to answer, but I mean, it would, as the enforcement agency, whether we feel like, there's the teeth in terms of additional protections, but teeth in terms of like making sure that more and more people are actually complying with the law. Well,
there's definitely, we've learned that the law is silent on the question of providing incorrect information. So, you have to, there's a maximum $10,000 violation if you don't register in a given year. But if you do and you just give false information, there's actually not anything written into the law that specifically addresses that. So that is certainly something that we've recognized. And as far as violations for not, I do think that I've seen some pretty good compliance from the larger entities. The smaller ones, yeah, that could be something that would be worth looking at. One question I would also like to raise to the group and hear about is, in the original law, we created something called a data broker data breach. And the reason for that was because of the recognition that a lot of data brokers, data breach, in order to have, if you have a data breach, you have to notify the people who are affected. But data breach is limited to a very small subset of data, which we learned in our investigation, a lot of data brokers intentionally do not collect. So a data broker might collect 10,000 pieces of data about you, but not your social security number. And then if they lose all that data about you, they don't have to tell anybody. So we created this thing called data broker data breach. And we kind of got into, I think, negotiation fatigue near the end of the thing. And basically what we had was, at the end, if you have a breach, when you report, you just have to say the number of breaches you had. I'm not sure anyone's ever reported having had a breach, including some data brokers that we absolutely know had breaches, and just put 0 in the list. So, you know, the question is, does it make sense to bring that law more in alignment with all the other data breach laws and just say if a data broker has a breach, including this kind of information, they need to tell consumers that they lost their information, just like anyone else who has a data breach of people's information. That's not currently a requirement of the law. Does anyone have a thought on that? There are no objections.
So I have no objections to that inclusion. It's a best practice now and well established. I would imagine that most data brokers, companies collecting data, would be able to comply with this.
Phil, we can't hear you, and you're still muted. I don't know if you know.
And still frozen.
I will get better. Yes, I agree. I completely agree.
All right. Do we have any other items we should discuss before we say goodbye for the moment? And we'll be looking forward to receiving some written comments, no doubt, from some of you. Feel free to reach out anytime to either Ryan or me if you want to talk through anything. Let us know. So this is my plan. Ryan and I are going to work on this. I'm calling it a report. It'll probably be more like a memo. We will send it to the chairs of House Commerce and House and Senate Economic Development. I will send it also to the whole, like whoever I emailed this morning. If you didn't get an email this morning, Ryan will chat my email address in the chat box, and you can just email me and say, please add me to the list. And I'm sorry that I didn't do that earlier. So once we have the report, I'll send it to you as well, so you'll get a copy. And then our hope is that these committees in the legislature will take up this topic in January, February, so we can get cracking. Yep. Really, really great conversation today. Really appreciate it. Anybody else? Last remarks?
Well, just one point of clarification on
Yeah.
that. 'Cause I think you mentioned like we want to submit some sort of written comments by the 15th. By the 15th, written comments, and then that in addition to these hearings will inform a final report that you're
Yes, absolutely.
Yes.
Absolutely.
Okay.
Yep.
So comments by December 15th?
Yes, that was my hope. If folks could try to get them to us by then so that we can, I mean, my goal is that by early January, maybe even the end of the year, although it depends on how much vacationing we're doing here. We might, get ready to start the session with that information to the committees about the conversations that we had in these forums and where the Attorney General's thoughts are right now on these topics.
Great.
I'm sorry. Could you just give us your email address just so I could write it down?
Just texted it in the chat. Can you see the chat?
It's charity.clark@vermont.gov.
And that's
Okay.
CLARK.
No E.
No E.
I'd like to buy an E.
Already not Clark. Okay, terrific.
Maureen, did you have something you wanted to add?
Oh, just a question. So are these formal comments that are going to be made public, or can we, jot down some thoughts and send them over?
I mean, you can jot down thoughts, but certainly subject to a public records request, they'd be available. So I would just, bear in mind that they can be public.
Okay,
Yeah.
thanks.
My thought was, because we have experienced that these forums, sometimes folks are representing others and they really need to kind of go back and have a conversation with them before they can really provide remarks. So I want to make sure everyone knew you can provide remarks in this more formal way and, be having the conversations and then writing it down. So my intention was to attach those remarks so that other people could have the benefit of reading them, and they are public records anyway. So yeah, be mindful of that.
Okay.
All right, Phil, your hand is up, but I'm thinking it was up from before.
Okay.
All right, so we're going to say, great to see everybody. Happy almost Thanksgiving, and be well.
Thank you.
Thank you. Take good care and happy Thanksgiving.
Same to you,
Thanks,
Pam.
Charity. Thanks, Ryan.
Thank you.
Bye, Chris.
Thanks, everybody.